Welcome. I'm Stephanie Bivens, and one of the attorneys here at the firm of Bivens and Associates. We're so happy you could join us today for this important discussion about estate planning and divorce, and how a divorce can impact your estate plan and what you need to know to protect your family and achieve your desired outcomes. I'm very pleased to introduce to you today attorney Hannah McGuire. She's going to be our speaker and tell you everything you need to know to do things the right way. We're scheduled for an hour. We may not go an hour, but please do enter any questions that you might have in the Q&A chat feature, and we'll be sure to address questions either as we go or at the end of our presentation today. So with that, Hannah, I'm going to hand it over to you and take it away.
Thanks, Stephanie. I will go ahead and share my screen here where I'm going to put up the slides. All right. So today we're talking about divorce and your estate plan, navigating that transition. So first, Stephanie already mentioned, my name is Hannah McGuire. I'm an attorney here with Bivens and Associates. A little bit about our firm. We practice estate planning as well as probate and trust administration, business entity formation, elder law, special needs planning, guardianships and conservatorships, and long-term care planning. So we've been around a long time, and if you have needs in any of those areas, our firm practices in those areas. So with that being said, today we're talking about divorce and estate planning. Divorce obviously not being within that scope of things we just listed, but we're going to be talking more about the intersection and how that process, that divorce system impacts your estate plan. So, first, obviously, when we're talking about your estate planning, we're really talking about mainly this group of documents, right? So things like your trust, a last will and testament, financial power of attorney, healthcare power of attorney, living will, HIPAA waiver, all of those. So that's sort of the sort of overview of when we're saying estate planning documents, when we're using that term. Those are kind of the main things that we're talking about. And for the purposes of today, we want to talk about how can these things be impacted by a divorce, and what should you be thinking about if you're going through a divorce with these documents. So the first thing to kind of note, this comes from divorce statute in Arizona, but while a divorce is pending, both parties are enjoined from transferring, concealing, selling, or otherwise disposing of any joint, common, or community property, except in the usual course of business, necessities of life, court fees, and reasonable attorney's fees associated with that matter. So with that being said, that's kind of one of our main considerations. If you're coming to us and saying, all right, I'm going through a divorce, what should I be thinking about? What should I be changing? One consideration initially is going to be as far as moving assets, funding a trust, dealing with, the estate planning, beneficiary designations, really just making any changes to your assets. The specific asset changes should be done after a divorce is finalized and a court has issued an order, a dissolution of marriage, and then the assets are ultimately distributed to each spouse. So as we go through, keeping that in mind, I will, call back to this principle, I guess, as we go through the presentation. So with that in mind, what things can you update and what things can you not update before the dissolution is issued? So prior to the ultimate dissolution being issued, you can update medical directives. We'll talk a little bit more about what that specifically looks like. You can update your financial power of attorney. you can update your will, right? And ultimately say, you know, this is now how I want things to go. And depending on the circumstances, possibly a trust. You know, obviously, if you have a joint trust with a spouse, you know, you can't necessarily change the nature of the assets or things like that, or just outright revoke the trust and say, this trust is no longer good. That kind of goes against that principle I mentioned earlier that comes from statute, which would, you know, stop you from changing assets. However, you know, we can set you up a separate trust, right? And have that trust in place, where you have an individual trust, and then ultimately fund that after dissolution with, you know, the assets once they've been distributed. So obviously a trust, you would want to talk through your specific situation more with an attorney about maybe what you can and can't do. But, you know, those are a couple of options that you can consider when you are thinking about your estate planning in the wake of a divorce. Obviously, once the divorce is finalized and the dissolution is issued by the court, then you can complete any trust updates and trust funding. So like I mentioned, you know, we could, you know, while things are pending, do a new trust, but to ultimately put assets into it and get it funded, that all needs to be done right once the dissolution is final and there's no injunction against moving any assets. And we have a clear answer of like, what's yours? And that can go into your trust. Obviously, any documents that you didn't update while the divorce was pending, right? Your medical directives, your financial power of attorney, really any of your other estate planning documents, a will, a trust, you want to make sure those are updated post-divorce. And as we go, I'll talk through a little bit of the considerations with that as well. And then beneficiary designations. Once the divorce is finalized, no matter who your beneficiaries are, you know, you want those to be updated to reflect that post-divorce that those were your wishes then. So those are the things to think about that, you know, we can help you with and at what point in time. As far as, so I mentioned medical directives. So for us, medical directives entail healthcare and mental health care power of attorney. So this is the document where you are appointing trusted individuals who would make healthcare decisions for you should you no longer be able to. So let's say you're under anesthesia, who is going to be the person to direct your doctor, something like that. That's who we're nominating there and giving some of your specific healthcare wishes as well. Your living will is the document that's giving medical professionals your end of life medical wishes. So, you know, that is part of the medical directives. And then a HIPAA waiver as well, just saying these are the people who can talk to my doctors, get medical records. I waive medical privacy for them. So that's sort of what I'm talking about when I say medical directives. Those are the documents that, you know, are included under that umbrella. So obviously, like I mentioned earlier, you know, we recommend updating medical directives if you're going through a divorce and or post-divorce, either one. You want to do that as soon as possible because a medical professional, if something happens to you, is going to defer first and foremost to your medical directives. So we want to make sure that your trusted individuals, maybe that's changed, maybe that's the same. We should reaffirm that by having you sign, you know, a new power of attorney, affirming who your agents that you want and trust would be, and have them in place in your documents, ready to step up if needed. On the other hand, if you have no medical directives, you know, the first person a medical professional is going to defer to is a guardian. So again, you become incapacitated, you become under, you know, in a coma, under anesthesia, something like that, where you can't give your own directives to your doctors. They're going to defer to a guardian first. A guardian is appointed by the court Most people don't have them. So if you are in an emergency situation, medical professionals then have the option, if you don't have a guardian, to defer to something called a surrogate decision maker. Again, this is where if you don't have documents in place, this is who they're going to go to for a decision. The first person is a patient's spouse unless the patient and spouse are legally separated. So this again is where, maybe you're just in the first stages of a divorce, maybe a divorce hasn't even been filed yet, but that's the plan. Your spouse still has priority to be your surrogate decision maker. So when you're thinking about your wishes and what is in your documents, this is where we want to be as clear as possible, because the alternate could possibly be that your spouse, someone who you are potentially divorcing or in the process of, could be the first person nominated. So again, that's where this intersection comes in of where estate planning is really important, and something that, probably is not top of mind if you're going through the process, but can become really important really quickly if there's ever an emergency or something like that, during the process of a divorce. So that's the first person. Then I've just listed the rest of the succession here. So the next person would be an adult child, where the medical professionals are trying to seek consent of the majority if there are more than one adult children. A parent of the patient would be next. If unmarried, a domestic partner, then a brother or sister, then a close friend who's exhibited special care and concern for the patient's care. And can act in accordance with their best wishes. So that's the succession. If you do not have documents in place of, okay, who are they going to defer to, in an emergency situation where you can't make your own medical decision. The next document is the financial power of attorney. So very, similar idea, right? You get into a situation where you can no longer manage financial matters on your behalf. In a financial power of attorney, we're going to designate agents who can manage those for you. So, similarly, you're in an accident, you have an illness that prevents you from managing your own finances, something like that. Who can step in and pay your bills, make sure, your investment accounts are still managed, make sure that, all finances are just taken care of, and mainly care for you, right? Make sure that everything that you need is getting paid for, and all your bills and everything to maintain your standard of living is taken care of. So again, we want to make sure we are appointing trusted individuals, and having that financial power of attorney in place, because the alternative is that if you get into a situation where you can no longer manage your financial affairs and you don't have, documents in place, a conservatorship would be needed to appoint for the court to appoint you a conservator who can manage finances on your behalf. Obviously, most of us would prefer that we just choose our trusted individual if we are in that situation. So very few people that we ever meet with are like, yeah, I would love to just have a conservator one day. That's obviously one of the really important documents at any stage for us to have in place for you, because this is a process that most people and their loved ones all just want to avoid. With that being said, speaking of the intersection with divorce, one thing to keep in mind as we talk through this is obviously your financial power of attorney is going to control who you designate. But alternatively, if you have not designated someone and a conservatorship is needed, then the court has a succession in place, again, similar to a surrogate decision maker, of who would be nominated as your conservator. The first person is the spouse of a protected person, and they don't even include the limitation of legally separated necessarily in this statute. So with that being said, obviously, when a divorce is pending, we want to make sure we're updating your documents to reflect that if something happens to you financially, you have your trusted individual in place, and maybe that's no longer your spouse. And then we can avoid them potentially being your conservator while the process is pending. So that's one consideration to think about. The succession is similar afterwards: an adult child, a parent, or a person nominated by a parent for a minor of a deceased person, any relative who has resided with the individual for more than 6 months prior to filing, a person who's carrying or paying benefits for the individual, if the individual is a veteran, then the Department of Veteran Services, and then the statute goes into a little bit more detail about different fiduciaries, but then possibly a fiduciary. So again, most of us like to feel some control over who we're naming, and if a divorce is pending, we definitely want to update your financial power of attorney for sure. And even afterwards, obviously, if it's finalized, we also want to update it and affirm whatever designations you've made or whoever it is that you would want at that point. Those are, the things I just talked about, the powers of attorney. Those are kind of the things during your lifetime that would be applicable. So on the other side, let's talk about what would happen post-death with some of the estate planning documents. So what if you die intestate and you never execute a will or a trust in the wake of a divorce? If you have divorced your spouse, a spouse is the first person eligible to be your personal representative intestate and also to receive your intestate funds, your estate, if you will. They would be entitled to receive that as an heir. If you are divorced, then they wouldn't be eligible to be the personal representative, also known as an executor, is what people often refer to a personal representative as, or to receive under your intestate estate. Obviously, this is again where it becomes important. If your divorce is pending, not finalized, we want to be really clear with your wishes in that interim gray period where you're not, you filed, but it's not final. There's been no dissolution issued. That's a really important time of where maybe we should do a will for you to just be really clear of if something happened to you in the meantime, where is everything going to go? What if you, alternatively, what if you have a will or a trust, so you don't die intestate, but maybe you didn't update your documents, or you have an ex-spouse who's still in your documents as someone named in, whatever capacity it may be. Let's talk through that a little bit. So an ex-spouse, a decree of dissolution, right? The termination of the marriage by the court will revoke the ex-spouse as a beneficiary or devisee of your estate planning documents. So again, this is where it becomes really important to make sure your documents are what you wish, because sometimes people still want their ex-spouse to be included, or maybe to name, some amount to go to their ex-spouse. And they think, oh, I have my planning set up how I want it. I won't update it. It's okay. We got divorced, but that's okay that they're still going to get my estate. Well, they actually would not receive your estate. In the case of a will, if they're named as the first beneficiary or the first devisee of the will, and then, you have, let's say, your brother as your contingent devisee, well, technically your ex-spouse is going to get skipped altogether, and your brother is entitled to everything. And again, this is where obviously we want to make your intent very clear. So even if you want to keep those documents exactly the same, you want to keep it so that your ex-spouse still receives, and then your brother is the contingent if they predecease you, then let's re-execute that document and update showing that was still your wish. Otherwise, that, that portion of the will can be revoked. Any power of appointment, so any power your spouse had to distribute funds from a trust through their will that they do, that power would be revoked by the dissolution of marriage as well. Any nomination of the ex-spouse to any pretty much any role in the estate planning documents, right? The personal representative I mentioned, that's like some people call that an executor, the trustee of a trust, to be your conservator, your agent. So the agent is what we call someone under your power of attorney. So your financial or healthcare and mental health power of attorney, that designation could be revoked. Someone as your guardian. So again, this is where we want your documents to be really clear, because if you just execute documents and you say, oh, I already had everything going to my kids, right? Everything was already going to go to my kids, and my ex-spouse is just the personal representative or the trustee even, just to distribute it to them, right? Well, that's actually going to be revoked if you don't update it by virtue of being divorced and then not updating the documents afterwards. That designation of your ex-spouse as trustee or personal representative will be revoked. Same with, the powers of attorney, right? If that's still your trusted person, and for some people it is, who you would want to name as your agent, well, actually, a bank is going to be able to look at that and say, oh, this designation is revoked because they're ex-spouses, and we have a copy of the dissolution from when we split the assets, right? So all those things. So that's why no matter which way, who you want to nominate, in updating these documents is really important. This next one, same idea. So if you own property, right? So real property, a home, for example, as joint tenants with right of survivorship, or as community property with right of survivorship, either one as a married couple, that interest is going to be severed when you ultimately have a dissolution of divorce, and the ex-spouses become tenants in common, which means that if one of them dies, the other's share no longer automatically passes to the other spouse, right? With that right of survivorship. The right of survivorship is gone. Now they're just joint tenants, right? So just two owners, and their share just has to pass according to whatever estate planning they do, right? So their will, or if they die intestate succession, whatever the case may be, is going to designate how something in their individual name will ultimately be distributed. Again, that can become very complicated because let's say you both remarry and maybe both spouses have new children. You could have, if it passes to new children over here and then new children over here, we probably got too many cooks in the kitchen, as they say, too many co-owners, too complicated. Like, we want to be really clear about, all right, what's happening with that interest. Let's get that resolved and make sure there's a clear succession there of how you want it to be, and not necessarily just how it would end up. So I mentioned beneficiary designations earlier, and I said, we would come back to this a little bit as we go through. So beneficiary designations, no matter who you want to name, should be always updated after a divorce, no matter who you're naming. So a beneficiary designation made prior to the date of the dissolution of marriage is going to be revoked. So if you, let's say, have an IRA and your ex-spouse is 100% beneficiary, primary beneficiary, and you just want to keep it the same way, you are okay with them being your beneficiary, well, that's actually going to be revoked. And if you don't have a contingent, well, now we need some way to collect this IRA, right? This IRA is just sitting out there in your individual name, no beneficiaries. That's going to be part of your estate, and likely, depending on the value of it, but likely a probate will now be needed to go and collect it. So, again, something that you want to avoid. Of course, if you have contingent beneficiaries, they could receive, but again, we want to be really clear about your intent, because there are times where people do get divorced and do rename their ex-spouse because that's still who they want to be the beneficiary. And, you know, obviously clarity in estate planning is very important. So we just want to be as clear as possible. So no matter what, after the date of divorce, once the assets are distributed according to the dissolution, update those beneficiary designations. The alternative, and something that a lot of people want to avoid, is that many retirement plans are actually governed by federal law, also known as ERISA. So they're not subject to Arizona laws, including Arizona's automatic revocation statute, which would say that an ex-spouse is skipped over, right, as a beneficiary. Their beneficiary designation is revoked. You could end up, if you have a federal employee plan, still having your ex-spouse named and your ex-spouse still receiving, even if maybe that wasn't your intention. So again, either way, whether you want them to receive it or not, we want to be making sure that on all retirement plans, particularly federal retirement plans, that you are updating those, so that, well, one, someone doesn't get skipped over if you don't want them to get skipped over, and alternatively, that they, you know, do get skipped if you want them to, right? That you're taking them out of your estate planning if that's your intention. So, you know, obviously, just to reiterate, no matter what you choose, always after the date of dissolution, you want to update those beneficiary designations. Then it's clear to all involved that that was your intent. Obviously, considering the divorce was finalized, and you know, then the financial institution and your beneficiaries have less hoops to jump through to figure out, you know, less gymnastics, if you will, of date of divorce, date of death, date, you know, all this things that they're figuring out of whether your beneficiary designations are valid. And obviously we want all of our planning that we do to be valid. That's one of our big goals. So as far as, you know, considerations with all of your estate planning, the best practice in the event of divorce is to update all of your estate planning. Like I said, there are drawbacks if you know, we want to reiterate things that would be the same, and we want to change things that would be different. Obviously, the whole goal of all of this is to make sure that your ultimate intent is achieved with your estate planning. And the best way to do that is to really update your estate planning documents in the event of divorce. And then just calling back to kind of that first thing that we're thinking about, right, throughout the whole process, is that injunction against moving, you know, community assets, things like that during a divorce. Once that dissolution is signed, all, you know, we are very clear on which assets belong to who. Then obviously you want to make sure funds are properly titled to a revocable trust, if you've designated one, and that all beneficiary designations are current and consistent with your most recent wishes at that time. So those are the big, you know, things to take away, is that you definitely want to be conscientious of your estate planning if you are, you know, in the process of, you know, going through a divorce, dealing with separation, something like that. We want to make sure that your wishes are accomplished, and then mainly that you're taken care of, right? Because during your lifetime, those financial powers of attorney are what, you know, determine who's going to be kind of the helper, right, that steps in, whether it's medical or financial. And we want to make sure you've got trusted individuals in those roles. With that being said, I'm happy to take questions. I've also put up my contact information here. So if you, you know, want to discuss any of this further, you can feel free to contact me here. And I will go ahead and actually close this for now so that we can talk about any questions that there may be.
And if you do have questions, you can go ahead and submit those through the Q&A feature on this live webinar. And And Hannah, while we're waiting to see if anybody has any questions here, I've been in the trenches for a very long time, over 25 years practicing. So I've seen, some unusual things happen when people don't update. One of the big situations that parents will be concerned about, particularly if they're getting divorced and they have younger children, is the potential if worst case scenario, and they died after they got divorced and their children are going to inherit, but the children are not yet 18 and they didn't update their estate plan. I've seen a scenario where the ex-spouse will end up being in charge of the inherited monies for the joint children. And that might be okay. In some scenarios, you might want your children's other parent to be managing the money for them while they're young. But there are certainly cases where you would not want their parent to be handling the money. And perhaps that was part of the reason that led to the divorce, was disputes about differences in money management styles. And so that can be a huge motivating factor for somebody to make sure that they get their estate plan updated after they're divorced, particularly if they do have minor children, just to make sure that the person you want is going to be in charge of the funds until those children are of an age, whether it's 18 or 30, whatever you decide would be an appropriate age for the child to take over and either receive the funds outright or start managing them in trust. I actually was involved in a case years ago where it was a divorce among two mature adults, as we like to say. And the wife in that scenario suffered a major medical issue before the divorce was finalized, and she became completely incapacitated. If memory serves me right, it might have been a stroke. So nobody really anticipated that was going to happen. And she had not updated her healthcare power of attorney, and her soon-to-be ex actually made the end of life decision for her rather than her children from her first marriage, because it was a late in life marriage and also a later in life divorce. And fortunately, in that scenario, the family all was consulted and agreed that decision was consistent with her living will, that she would not have wanted additional medical treatment at that point, given her prognosis. But he also inherited everything from her because they were not yet divorced, and her estate was left to him under their current estate plan, which the children were not happy about because they didn't believe that was consistent with what she would have wanted, because they were getting divorced and given the nature of the acrimony between the two of them. But the children had no legal basis to make anything else happen. In that case, had she pre-stroke been able to update some things, I think we could have had at least a partially different outcome. So, nobody ever anticipates these kinds of things happening, but they can. And so, it's just important to know that you don't have to wait until the divorce is final to at least do some updates, so that if something happens before it's final, we may have a smoother path to taking care of things with the right people as the decision makers and the advocates for the spouse who's getting divorced, who now is having health challenges. So just a couple of tales from the crypt, so to speak. Let me see if we have any questions. I don't see anything popping up here. One of the things that you mentioned, Hannah, that I think is so smart is for people to consider is, once the divorce is final, obviously updating everything, but doing a new trust for themselves and putting their assets in trust. If they get remarried later, the assets owned by the trust are very clearly their sole and separate property. So if there's another marriage followed by a divorce of that additional marriage, the assets that are in the trust are very clear if the court in a second dissolution proceeding is reviewing the assets as to what is spouse one, spouse two versus joint, it's very clear that the trust assets that were owned and entitled to that trust prior to the marriage are the separate property. And you can't accidentally commingle and lose those assets in a subsequent divorce. You can't accidentally commingle and add a spouse's name onto the trust account, thereby giving them presumably a 50% community property interest in those what formerly owned separate property assets were, meaning the assets owned prior to marriage. So updating one's estate plan post-divorce actually can help if it's done in a trust and everything is titled correctly. If there's a remarriage and a second divorce, or third, whatever the number is later down the road. So it kind of helps people years in advance of what they're even thinking at that time. Any other thoughts or pearls of wisdom, Hannah, we want to share before we wind down our webinar today?
Thoughts and pearls of wisdom. If going off of your last point, if you are thinking about getting remarried at that time and preserving assets, prenuptial agreement can always be a useful tool as well. So I'll just make a little note about that. And if you need assistance with a prenuptial agreement, we can be of assistance with that as well. But other than that, obviously, like I said, a huge priority, and I think that's echoed in a lot of what Stephanie said, is, obviously caring for you during your lifetime. One of our big goals is always making sure we've got trusted individuals around you and in your documents and named. So obviously that is important. Also, clearly, like Stephanie said, making sure everything is going to where you really want it to go. We want to help you accomplish that and help you keep on track with whatever your goals are for your estate planning, of achieving those in our planning. So just making sure that, major life changes such as divorce, always call for a look inward at the estate planning documents that you've got.
Exactly. So we're going to go ahead and conclude this a few minutes early today. But if you're in Arizona and you have estate planning questions, you just want a review of your estate plan, perhaps you're going through a divorce or you are divorced and you realize you've not had a review of your estate plan since your divorce has been finalized, we're here to help you with that. So feel free to call the office. Our contact information was on the slide before, and we're here to help. So with that, thank you very much for joining us, and we hope this information was helpful for you and beneficial for those you care about.
Thank you.
Have a great day.